The Supreme Court has just released a major decision involving President Trump's tariff policies and whether the president exceeded his authority with sweeping reciprocal tariffs on other nations, the centerpiece of his economic agenda. Let's get right to ABC's senior Washington correspondent Devin Dwyer, who covers the Supreme Court for us. Devin, your thoughts?
Kira, this is one of the most significant decisions on presidential power in decades. The Supreme Court, just moments ago, in a 6-3 decision authored by Chief Justice John Roberts, invalidated most of President Trump's tariffs. 70% of the tariffs he's imposed so far in his second term here have been under the law known as the International Emergency Economic Powers Act. It was written in 1977. He claimed it gave him unlimited power to tariff any country at any level for as long as he wants.
Hey guys, Adam speaking. What just happened at the Supreme Court is not a routine legal ruling. It is not another political headline you can scroll past. It is the single most significant judicial check on presidential power in the entire second term, and it landed with the force of a constitutional thunderbolt that is still sending shockwaves through every corner of the executive branch. Chief Justice John Roberts just wrote a 6-3 decision that did something the legal establishment has been waiting to see for years.
In a surprising development, the U.S. Supreme Court has ruled that President Donald Trump's sweeping global tariffs are illegal. In a 6-3 decision, the justices found that Trump exceeded his authority under federal law when he imposed tariffs using emergency powers. Chief Justice John Roberts wrote the majority opinion, emphasizing that the president cannot unilaterally impose tariffs without clear congressional authorization. The court said the emergency powers Trump relied on falls short of giving him that authority. The majority included Chief Justice Roberts and 2 other conservative justices, alongside all 3 liberal justices, including Ketanji Brown Jackson, Elena Kagan, and Sonia Sotomayor. Dissenting were justices.
He did not just rule against the administration's tariff program. He dismantled the entire legal theory behind it. He looked at the argument the White House had been using to justify sweeping economic power and said, in writing on the record, that the president cannot do what he claimed he could do. Not that he did it wrong, that he cannot do it at all.
The future of President Trump's tariffs, at the center of his economic agenda, is now in the hands of the Supreme Court in a case Trump says is literally life or death for our country. President Trump is turning to a 1977 law called the International Emergency Economic Powers Act, or IEEPA, to claim he has the power to impose tariffs unilaterally, even though IEEPA does not mention tariffs, and the Constitution says this power belongs to Congress. By declaring the fentanyl crisis and trade deficits emergencies, the Trump administration argues because IEEPA says the president can regulate importations, that includes tariffs, something no president has done before.
Those 2 words are going to haunt this administration for the rest of its term. He cannot. The case is Learning Resources versus Trump. The ruling is 6-3. The author is the Chief Justice, and the holding is devastating. The Supreme Court just ruled that the International Emergency Economic Powers Act, the statute the administration had been using as the legal foundation for its massive global tariff program, does not authorize any president to impose tariffs. Full stop. Not that the specific tariffs were too broad, not that the emergency declaration was flawed, that the statute does not give the president that power. Period. Let me put this in perspective for you. The Liberation Day tariff program was one of the signature economic policies of this administration. Tariffs of up to 25% on imports from countries around the world, tens of billions of dollars in duties. A global trade war launched through executive action, and the Supreme Court just ruled that the legal authority the president claimed to do all of it never existed in the first place. Roberts wrote that the Constitution vests taxing and tariff power in Congress. Article 1. The legislative branch, not the executive, and for the president to impose tariffs through an emergency declaration, he would need to show clear congressional authorization for that specific power. The administration tried. It could not. And the court said so in language that leaves no room for interpretation. He cannot. Now I want you to understand the full weight of what just happened. The International Emergency Economic Powers Act was passed in 1977. It gives presidents authority to regulate international commerce in response to extraordinary threats, freeze assets, block transactions, impose sanctions on specific actors in specific crises. What it was never used for, never intended for, never designed for, was imposing across-the-board tariffs on every import from every country in the world. The administration's theory was that citing drug trafficking and trade deficits as national emergencies somehow unlocked unlimited tariff authority under this statute. Unlimited amount, unlimited duration, unlimited scope. It was an expansion so far beyond the original design of the law that Roberts characterized it as a claim of authority Congress never granted. And the court just shut it down. The constitutional backdrop here matters enormously. The taxing clause gives Congress the power to lay and collect taxes. The tariff clause gives Congress the power to regulate commerce with foreign nations. The Constitution specifically assigned those powers to the legislative branch. Displacing that assignment through an executive emergency declaration requires the clearest possible congressional authorization, and the court just ruled that IEPA does not provide it. This is what the major questions doctrine looks like in action. When a president claims authority to take actions of vast economic and political significance through an executive order or emergency declaration, the claimed authority must be clearly stated in the specific statutory text being invoked. General grants of executive power are not enough. The tariff program was exactly the kind of vast economic action the doctrine applies to, tens of billions of dollars in duties. Trade relationships with countries around the world reshaped overnight. Prices across the entire American economy affected. For an action of that magnitude, the president must identify specific statutory language that clearly authorizes that specific type of action. He could not. Now let me tell you why this matters so far beyond the tariff context. The clear congressional authorization requirement that Roberts just applied is going to shape the judicial review of every other major executive power claim this administration has been advancing. The attempt to fire Federal Reserve officials, the claim of unlimited removal power over independent agency heads, the assertion of broad immigration enforcement emergency authorities, the use of national security framing to justify domestic policy actions. Each of those claims involves an assertion of vast executive authority in a domain of significant economic or political consequence, and each of them now faces the same analytical question. Does the specific statutory text clearly authorize the specific action being taken, or is the administration inferring authority from general statutory language in ways the major questions doctrine forecloses? The tariff ruling does not decide all of those questions, but it establishes the framework that will be used to evaluate them, and that framework is considerably more demanding than the broad deference to executive emergency power claims the administration had been banking on. Let me give you the immediate practical consequences because they are staggering. The duties struck down in the Learning Resources ruling covered the IEPA-based tariffs that were under review in that specific litigation. But the ruling's legal analysis applies to the entire IEPA tariff program. Every tariff imposed under that emergency authority is now subject to the same legal infirmity. The administration is going to face immediate legal challenges to every other IEPA-based tariff based on the ruling's framework. And the prospect of courts applying the same analysis to invalidate the remaining IEPA duties is what is driving the urgency of the administration's effort to rebuild the tariff program under alternative statutory authorities. Then there is the refund question. Over $100 billion in duties already collected under the invalidated program. The standard process for recovering illegally collected customs duties involves individual importer claims through the customs protest and refund procedure, a process not designed to handle the volume of claims the IEPA ruling potentially generates. Trade courts have issued orders directing the administration to begin processing refund claims, but the mechanics of actually returning over $100 billion in collected duties is genuinely unprecedented. Years of additional litigation are coming. Now let me talk about how the White House responded, because the language used in the aftermath of this ruling reveals something deeply significant about how this administration views constitutional limits on presidential power. The president called the ruling terrible, absolutely flawed, said the court hurt the country badly, accused the justices of lacking courage, said they ought to be ashamed, and then he used a word that deserves careful examination. He said the court ransacked America. Ransacked. That is the language of destruction, of violent seizure, of something being taken from the country against its will. What was taken? The court enforced the constitutional distribution of power between Congress and the executive branch. It ruled that Congress controls tariff power, just as the Constitution says, and the president characterized that as the court ransacking the country. When you step back from the immediate political reaction, what you are seeing is a statement that constitutional limits on presidential power are themselves harmful, that the separation of powers framework is an obstacle rather than a feature, that a court enforcing those limits is doing damage rather than functioning as designed. That is not political rhetoric about a legal loss. That is a fundamental disagreement with the constitutional structure itself. The ashamed of itself accusation paired with the lacking courage characterization reflects the same transactional loyalty theory of judicial appointments that has been a consistent theme throughout this administration. The president views the justices who ruled against him, including his own nominees who were in the 6-justice majority, as having failed a test of institutional loyalty rather than having exercised legitimate judicial independence. In the failing courage framing, suggesting that the correct ruling would have required the political courage to support presidential power against congressional limits, the specific error in the constitutional theory becomes visible. Judicial courage in the constitutional tradition means having the independence to rule against powerful interests, including the interest of the appointing president. The president's use of the term suggesting courage would mean ruling in his favor inverts the traditional meaning in a way that reveals how fundamentally his understanding of the judicial role differs from the constitutional design. The "he cannot" conclusion is the most important 2 words in the entire Roberts opinion. They establish with maximum judicial clarity that the specific theory used to justify the global tariff program does not exist. Roberts could have said the tariffs were excessive, could have said the emergency declaration was insufficiently specific, could have said the procedural requirements were not met. That would have left open the possibility that a more carefully constructed IEPA tariff program could survive. Instead, he said the president cannot impose tariffs under IEPA because Congress has not clearly authorized that power. A conclusion that forecloses the entire category of IEPA tariff authority rather than just a specific program. That categorical foreclosure is what makes this ruling a landmark rather than a case-specific loss. The clear congressional authorization standard applied to the tariff program is the most consequential legal framework the Roberts Court has established in the 2nd term. It applies to the entire range of vast economic and political significance claims the administration has been making across multiple policy domains. The administration's 2nd-term policy agenda has been substantially built on the theory that emergency declarations and general statutory authority combine to give the president broad unilateral power to act without specific congressional authorization. The tariff ruling rejects that theory, at least for actions of vast economic and political significance in the most direct possible terms. Every other major 2nd-term power claim now faces the same analytical question under the Roberts framework. The ransacked America and ashamed of itself characterizations are not just intemperate rhetoric. They are revelations of a constitutional theory that views the separation of powers framework as an obstacle to effective governance, rather than as the constitutional design that protects democratic accountability. The separation of powers is not a procedural technicality that can be set aside when it interferes with presidential policy goals. It is the foundational structural feature of the American constitutional system. When the president characterizes a court ruling enforcing that separation as ransacking America, he is characterizing the constitutional structure itself as harmful. That characterization, held by the person sitting in the Oval Office, expressed publicly after a landmark constitutional ruling, is one of the most direct available statements of the unitary executive theory's most extreme version. Here is what we need to watch now. The administration is attempting to rebuild its tariff agenda within the constitutional constraints the court just established. The alternative statutory authorities it is pursuing, Sections 232 and 301 of the trade statutes, face their own legal challenges under the same Roberts framework. Section 232 requires a specific finding of national security threat posed by specific imports. Section 301 requires specific findings of unfair practices by specific trading partners. Applying those statutes at the scale the administration wants to maintain requires stretching them beyond their normal applications. And the clear congressional authorization standard that Roberts established is the analytical framework courts will use to evaluate whether those stretches are permissible. If courts apply the Roberts standard and the administration cannot show clear statutory authorization for the specific scope of tariffs it wants to impose, the alternative program faces the same legal infirmity as the IEP program. Here is the bottom line. The Supreme Court just ruled 6-3 that IEPA does not authorize the president to impose tariffs, that the Constitution gives Congress the power over tariffs and trade, that the administration failed to show the clear congressional authorization required for claims of vast executive economic power. He cannot. Those two words close the IEPA tariff door categorically rather than procedurally. Tens of billions in struck-down duties, over $100 billion in refund questions. A legal framework that applies to the entire range of vast executive power claims across the second-term agenda. The president responded by calling the ruling terrible, absolutely flawed, saying the court hurt the country badly, accusing the justices of lacking courage, saying they ought to be ashamed, and characterizing the ruling as the court ransacking America. The six-justice majority included 3 of his own nominees on the conservative wing, Roberts, Gorsuch, Barrett, demonstrating that the transactional loyalty theory of judicial appointments is wrong and that the court is exercising genuine constitutional independence rather than reflexive institutional support. The power is crumbling, not in a single dramatic moment, but in the documented real-time process of a constitutional court enforcing the limits that the founders built into the framework of separated powers, limits that apply to every president, including the one who appointed the justices enforcing them.